Hello, I'm Rick Steele, and I serve as chair of the Licensed Psychology Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic media. Richard Nobles, Jonna Norton, Abby Callis,
I'm here.
Jessica Hamilton, Tiffany Johnson, Janine Kesterson,
Here.
Rodney McNeil, Zachary Parrott,
Present.
and Doug Wright.
Present.
I note the following staff members are also present: David Fye
Here.
and Leslie Allen.
Here.
Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting today, as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by Medium Interactive Communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended, so we will be conducting this meeting pursuant to KOMA. On January 10th, 2023, we sent notice of the advisory committee meeting to all individuals who had requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material have been posted on the board's website. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the members of the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may contact the board office by leaving a voicemail at 785-296-3240 or sending an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I did check that before the meeting began, and there's no individuals on the conference call line. And Rick, you are currently muted right now.
I am. Now I just caught that. Thank you, David. The meeting is now called to order, and the advisory committee will begin its discussion of the first, I said on the agenda, but I don't know that we can approve the agenda without a quorum. So until we have a quorum, maybe we should just go down to the executive director's report.
Thank you, Rick. I'll go ahead and provide some informational items in terms of my report for the advisory committee members. So there have been a couple of board meetings that have occurred since the last time the advisory committee met. Those were on January 6th and also on January 18th. The board has been working on considering a lot of items that could go into legislative changes in a bill before the legislature or into regulatory change before the legislature, or actually that would go through the regulatory process. And so I'll go ahead and provide a little bit of a summary in terms of some of those items that the BSRB has requested in regards to a bill before the legislature. And so today, the BSRB bill was introduced in the House in printed form. That bill is House Bill 2340, and it has not been assigned to a committee today because it was just introduced today, but it should be assigned to a committee probably tomorrow, and then it would be available to be heard in different committees for the House. And so I will be following up with the chair of the committee that it will be assigned to, requesting a hearing on our bill, hopefully sometime next week. Some of the items that are included in that bill include the board had voted to recommend changes to the reciprocity statutes for the professions. For the non-clinical level of most of those professions, there was language that said for individuals to apply for licensure by reciprocity, they either needed to come from a jurisdiction with substantially equivalent licensure standards or to have practiced in that jurisdiction for 48 of the past 54 months. The different advisory committees brought different recommendations on changes to that statute, and ultimately it was the will of the board to vote to recommend a consensus decrease down to 12 months for those individuals who are applying for licensure under that statutory provision of reciprocity. Second, there would be some language included in a bill to create a new type of temporary license. These would be for graduates of social work programs that are considered to be in candidacy for accreditation by the National Accrediting Body for Social Work, Council on Social Work Education, CSWE. This is modeled after a similar program that exists in the state of Minnesota for their licensing board for social workers, and that would be something to be considered by the legislature. But should that pass, then individuals who graduate from those programs that are in candidacy for accreditation would be able to get a temporary license while their program remains in candidacy. And then when their program reaches full accreditation, they would be able to get a permanent license. And Rick, Tiffany Johnson did log into the meeting, so she is in attendance today as well.
Great.
And Tiffany, I was just going through some of the items in my report for the committee. I was summarizing some of the items that are included in the bill that was requested on behalf of the BSRB. And so the next item that's included in that bill, House Bill 2340, is an item that would create a new type of addiction counseling student temporary license for individuals seeking to obtain the necessary coursework for a permanent addiction counselor license. The model is similar to what existed previously under SRS that was called a counselor in training. So that is something for the legislature to consider when they evaluate the BSRB bill. Additionally, the board voted to request statutory language to increase the time for temporary licenses. For most temporary licenses under the board, they lasted for 1 year. Some of them lasted for 2 years. But what the board voted to do would be to make all those temporary licenses last for 2 years. We had received information that some of the professions, some of those individuals who are taking the licensure exam were having difficulty passing that examination. And for individuals who are working under a temporary license, there's a window of time which they can take that licensure exam. So this would allow them to continue to work for a longer period of time while taking that examination. Additionally, the board requested statutory language to create a new pathway for individuals to request more time to complete their continuing education hours, which will allow more current licensees to continue to renew their license. The licensed psychology profession has a regulation, and this was modeled after that, which if an individual is coming upon their expiration date of their license, they could request additional time to complete those continuing education hours. And if they are approved, in the past, they had to show good cause for needing that extra time, then they could have up to 6 months additional time to complete the hours and still continue to renew their license. The board reviewed that regulation and agreed to go ahead and make a consistent change across the professions, which essentially would say that if you are coming upon your expiration date and you had extenuating circumstances, which were the reason that you couldn't complete your continuing education hours, you could apply to the board for a request for additional time. It would still need to be approved. You would need to show extenuating circumstances and a plan for obtaining those hours, and you could be approved for up to 3 months of additional time to get those hours, but it would allow more people to stay licensed and not have their license expire. So that was an item to address some of the workforce concerns. Additionally, the board voted to request statutory language to decrease the license reinstatement fee for some individuals that are seeking to re-enter the workforce if their license has been expired for at least 1 year. It would also add language to create and offer a new 6-month reinstatement temporary license. And these will be for individuals who wish to have their license reinstated, but they have not obtained all the necessary continuing education hours from the past license period to have their license fully reinstated. They could get this new special 6-month reinstatement temporary license and be able to begin to work while taking those necessary hours for the full license to be reinstated. So we think these two changes will be nice items to be able to create an incentive for people to rejoin the workforce if their licenses have been expired during the past because of some reason involving their own health or someone close to them where they stepped away because of burnout or any other issue. This was also an item the board was looking at and recommended a change to address some of the workforce issues. Additionally, the board voted to recommend board-approved supervisors for the social work profession. And also, as a recommendation for bill language, the board looked at continuing education hours for the different professions and looked at what is required in Kansas compared to other states. And it was seen that the requirement of ethics is a pretty standard requirement across the professions across different states. However, the board currently requires that for individuals able to diagnose and treat, that they have to have 6 hours in diagnosis and treatment every license period. And that requirement is a bit unique. You don't really see that very often in other states, although other states do have other categories called out in terms of their continuing education requirements. And so the Social Work Advisory Committee had recommended to the board a 3-hour requirement of continuing education in the area of diversity, equity, and inclusion. And so the board talked about continuing education broadly, and it was the consensus of the board to go ahead and decrease the number of continuing education hours required in diagnosis and treatment from 6 hours to 3 hours, and to add a new 3-hour requirement of continuing education and cultural diversity for all professions. And that definition of cultural diversity links to the current 6-hour requirement in the state of Texas for licensed psychologists that are required to get 6 hours of cultural diversity training every license renew period. And so that specific language is included in the BSRB bill. It would not go into effect unless that bill did pass, but it also defines what is listed under cultural diversity in terms of that definition in Texas. Further, the BSRB bill includes language to create a license standard for licensed psychologists that you spoke about at your last advisory committee meeting, changing the standard from good moral character to meriting the public trust, which is a more uniform standard with the other professions, and it better matches the standard in other jurisdictions as well. The BSRB bill would include language to add a new board member for the behavior analyst profession. Currently, there is not a board member for that profession, but this would add one, so the governor would appoint one if this bill did pass with that language. Also, the bill would add language to modify disciplinary remedies for the behavior analyst profession so that they are more similar to the disciplinary remedies for other professions. The language that was initially included in statute for that profession was very limiting. And so it only authorized the board to do extreme actions such as suspend a license or revoke a license, whereas the other professions include language to be able to do more disciplinary remedies such as issue a fine or do a public censure or things like that. So changing the language will make it more consistent with the other professions and will allow more flexibility for minor violations of the unprofessional conduct regulations. And then additionally, there's a number of statutory cleanup items that are included in the bill as well. So as I mentioned, that bill is House Bill 2340. There's also a Senate bill that is in the process of being introduced, and that Senate bill will have identical language to the House bill. But the reason there's two bills is because there's two separate health committees, one for the House, one for the Senate. And the goal, the hope is that both committees could consider the same language simultaneously without one having to wait for the other chamber to act before considering some of these items. So as I mentioned, I'll be talking with the chairs of the committee, trying to get a bill hearing for our bill, and then I'll provide updates to you after that. At those board meetings, I also wanted to let you know the board did take a couple of other steps too. One, we were in the process of changing legal representation for the board. In the past, we had received services from the Attorney General's office. This past week in budget hearings, there was some testimony by the Attorney General's office that indicated that they were having difficulty filling positions. That is something that we had heard communicated to us as well in the fall. From my understanding, I believe the BSRB was one of their biggest clients in terms of state agencies receiving services. So some of the individuals who have been providing services to us in the past are no longer with that office. And I think just like with a lot of other agencies, they were having workforce issues. And so the BSRB now is receiving legal services under an agreement with the Kansas Department for Aging and Disability Services. They're providing services to the BSRB through the remainder of 2023, which will end in June of 2023. And during this time, we'll be looking at other possible legal agreements with other individuals or other agencies in terms of legal services to the board after this fiscal year. Additionally, there is a professional counselor multi-state compact that has been passed by some states over the last 2 years. That compact commission just started having meetings in the fall of last year. It had not been considered by the Kansas legislature so far. However, the Kansas Counseling Association has requested introduction of that bill. That bill was introduced recently as House Bill 2288. And representatives from the KCA did speak to the board and requested support for that bill if it's introduced. The board did vote at the January meeting to support that compact legislation if it was introduced, and it has been introduced now. So I don't have a date for that hearing, but I expect that to also be sometime next week. So I'll be presenting testimony on behalf of the board to support that compact. Additionally, I mentioned that there were some statutory changes included in that bill. There are also some accompanying regulatory changes. Some of the items that the board has requested or recommended change in the regulations, including for the social work, addiction counseling, marriage and family therapy, and professional counseling professions. If someone came from a school that is not accredited by the national accrediting body, there are alternative requirements for licensure in the regulations. And one of those requirements has included that individuals would have to have received some of their education while physically present at the school. This comes back to the definition of in residence that we had talked about a little bit with some of the program approval regulations for the profession. Well, for the social work, addiction counseling, marriage and family therapy, and professional counseling professions, they recommended to the board removing that requirement of being physically present and to allow for the face-to-face contact in front of core faculty to be satisfied by face, in person, or by screen. And so the board did recommend changing that, so that is going through as a regulatory change currently as well. Additionally, for the social work profession, as I mentioned earlier, we had heard information about some individuals struggling to pass the licensure exam, and the board wanted to be supportive of any efforts that could be made to assist individuals if they're struggling with the different examinations. And so the Social Work Advisory Committee forwarded a recommendation to the board, which would allow for continuing education hours for individuals who are coaching or mentoring individuals who are studying for licensure examinations. And so that would be a new regulation that's working its way through the process. It would allow those individuals in the social work profession to be able to get up to 10 hours of continuing education if they are coaching or mentoring individuals who are attempting to pass that licensing exam every license period. Additionally, there's some regulatory language for the professional counseling applicants who are seeking to meet the alternative requirements for licensure. Right now it says that the person in charge of their program, that chair or directed individual would have to have a doctorate in professional counseling. The board recommended changing that so that the person directing or chairing the program could have a doctorate in professional counseling or an other related field, which is defined in the regulation. Currently, right now, individuals can apply for licensure if they have a degree in another related field. So this allows the person chairing that program to also have the same standard in terms of what position they fulfill. Additionally, for the master's level psychology applicants, there's a change to the regulations going through right now that will remove a certain requirement for a certain number of classes taught by core faculty to allow greater flexibility for programs using experts or other adjunct faculty. And then to reduce cost, the board recently voted to change the amount for temporary licenses so that all temporary licenses would be no more than $50. And this was in an effort to reduce cost for applicants and licensees and also to bring more standardization to the professions. And then tomorrow, there is a special board meeting on February 8th. And that short board meeting is to allow the board the chance to review recently introduced legislation to discuss if the board would like me to provide testimony on behalf of the board. There have been a number of bills that have a relation to the BSRB or to the licensees that we regulate. And so the board will be reviewing some of those at a meeting tomorrow. In terms of some legislative updates, this time period is for bill hearings, but also budget hearings as well. And the BSRB, like all their state agencies, presents our budget to both the House and the Senate separately. And there are budget committees that review that information. They can ask questions to me, and then they can make any changes. And so last week, the budget for the BSRB was heard before the House Higher Education Budget Committee. And this week, they made recommendations on the budget. They did not make any adjustments to the amount that was approved by the governor in the governor's recommendation. They did attach a proviso to the budget of the BSRB in the budget committee that would essentially prohibit the BSRB from requiring as a licensure standard any requirement of continuing education in the areas of diversity, equity, and inclusion, critical race theory, or a couple of other topics like that. And that was something that was a recommendation by the Budget Committee. It did pass out of committee, so the next step would be for that to be heard by the full House Appropriations Committee, and they have the ability to make further changes. Our budget is scheduled to be heard by the Senate tomorrow, and so I will keep you updated on any changes that Budget Committee makes on the Senate side. And then, like I mentioned earlier, the BSRB bill has now been introduced. It's in printed form, so we'll be working with both the House and the Senate to try to get a hearing on the bill. So with that, I will go ahead and end my report, and I can stand for any questions.
Thank you, David. Are there any questions? So there's an obvious conflict between that proviso that you just mentioned and our CE legislation in House Bill 2340. So we should expect the legislature to probably pull that out again.
Well, it's different groups. So the budget committees primarily focus on expenditures and revenue, but they can recommend different proviso language that would go into an appropriations bill that would say essentially notwithstanding any other provisions of law, you either have to do something or you cannot do something. And in this case, they did choose to include that language in the Budget Committee. Ultimately, the Budget Committee's recommendations are forwarded to the House Appropriations Committee, and they decide if they want to make further adjustments or not. And then the Senate will be doing the same thing with a Senate Budget Committee and then the Senate Ways and Means Committee. And then if there's any items of difference, that would go to essentially a conference committee, assuming that both bills pass on the Senate and House floor. But ultimately, any items of difference would have to be discussed, and then they would decide what would stay in and what wouldn't. And so we're still quite a ways away from that. I have reached out to the chair of the House Appropriations Committee, and I will try to meet with him to talk about that recommendation that was made by the Budget Committee. And so I will try to get more information on that and be tracking that. But essentially, that is the authority of the Budget Committee. They can put language like that into an appropriations bill. The committees that would be considering the BSRB bill, it is possible that the bill could be assigned to the Budget Committee, but it's more likely that the bill would be assigned to a Health Committee. And so that would be a separate group of individuals that would be considering that. So right now it's a little early, but that definitely is something that would need to be taken into account if the bill passes with the current language about the continuing education requirements changing.
Okay. All righty. Any other questions or comments? Okay, I believe we currently have quorum now, so we can go back. If you're looking at your agenda, we can go back to item number 2. And if someone would like to make a motion to approve the agenda as, I guess, as written.
Rick, I would move we approve the agenda as written.
Thanks, Doug. Is there a second?
Second.
Thank you, Tiffany. Any discussion? All in favor of approving the agenda, please raise your hand, say aye.
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 Any opposed? Okay, thank you. Item number 3 is review and approval of the minutes from our December 13th meeting. I believe those were sent out Friday. Was that Friday? Dave?
I think at the end of last week. Yeah.
Yeah. So if you want to refresh your memory of those, we will entertain a motion to approve the minutes.
I move we approve the minutes as written.
And I will second that.
Thank you. Any discussion? Any comments? All in favor of approving the minutes, say aye.
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 Any opposed? Great, thank you. So we've already had the executive director's report, which will bring us down to item number 5, which is old business. And Dave will give us an update on the SIPAC commission activities.
Thanks, Rick. And I don't really have a lot of updates from the SIPAC Commission. I did include in your packet of material the December 2022 Commission newsletter. The SIPAC Commission does issue a quarterly newsletter. At the last meeting, I provided an update on the individuals who are practicing under SIPAC authority in Kansas. According to the newsletter, this came out in late December, but at that time, the individuals practicing under the authority that SIPAC provides for teletherapy, there were 75 individuals, and then those individuals who are providing a limited number of days of in-state practice under SIPAC authority totaled 7. We did receive the annual assessment at the end of the calendar year by the SIPAC Commission, so we have paid that. There may be further discussions about removing that assessment in the future, but at least as of right now, that assessment still stands, and that is the $10 assessment to the state of Kansas per individual who practices under SIPAC authority, and that is basically looked back at the different states at the end of the calendar year. So we did have that, we did pay that. We've also gone through a couple of checks with the SIPAC Commission to ensure that we were still meeting the standards of the SIPAC Commission, and we received positive marks on that. So we are in compliance with the SIPAC Commission. There is one item that requires the BSRB to begin doing some background checks using fingerprints, but there is a 10-year time frame that the board would need to start doing that after the SIPAC legislation became effective. So we have a few more years to put that into place. We have some legislation that authorizes that, but we have not began that process of charging a fee for that process or working with Highway Patrol to go ahead and do that. But that would be something in the future we'd be looking at. Some of the other multi-state compacts also require that. So I've made the board aware that that's something on the horizon probably for us to be looking at. So there's really not a lot of other SIPAC updates, but I'll continue to keep you updated. There's likely to be a mid-year meeting of the SIPAC Commission as well as an annual meeting. And so I'll give you updates after those meetings when other items are being considered by SIPAC.
Great. Thanks, David. So also under old business, we began very briefly a discussion of topics for the advisory committee for this calendar year. One of those, and I think some of the other professions are engaging in a review of their educational regulations. My understanding is that this is part of kind of our ongoing effort to make sure that we don't have any regulations that have outlived their usefulness or regulations that that don't currently address current events, right? Current situation. And so we've got our education regulation, KAR 102-1-12, as a possible topic for conversation for this year. We can, I don't know that we necessarily need to go into that tonight. That's just kind of on the list of things to do. One of the things that we might want to consider, and we've talked about it before, is whether that specific regulation needs to be broadened to include programs, doctoral training programs that are accredited by PCSAS or others. And then the other thing we've talked about in the past was the language regarding how certain topics are covered. So in the language of the APA's Commission on Accreditation, those discipline-specific knowledge items used to be broad in general. So biological foundations, social foundations, developmental foundations. So those are some things that we can talk about this year. Are there other topics that any of you feel like we need to add to our list of agenda items for this year?
I don't have any agenda topics off the top of my head, particularly from a year-based perspective. I have a random, I need a reminder question about something we've talked about in the past, which can go at any point in time. It'll be a really simple question. I'll have to give some thought to the other one, like from a long-term perspective.
Okay. Do you want to mention your specific question tonight?
Oh, yeah, sure.
Sure.
I didn't know if you wanted me to do that right now.
That'd be fine.
Oh, I have had two students that I supervise come to me about the EPPP2 and getting some sort of idea that that was coming next year. And I'm not sure where it's coming from. So I wanted to make sure I didn't miss something about when that would be coming. And if anybody else had had that rumor floating around in their student population or intern populations.
I'm not familiar with that. The information that I received was that the incorporation of EPPP and EPPP2 into one test, the direction by ASPPB was that would need to happen by January 1st of 2026.
Okay, that's
still have a little bit of time before then, but I haven't heard any change to what that was provided in the fall of last year in terms of it being moved up to 2024. I know some states, they did provide some direction that said if there are states that want to move to that direction earlier, that would certainly be allowed. But that's really more on the states themselves to make that decision.
okay, excellent. That's what I thought. I just wanted to make sure because they both were very convinced that it was happening in 2024. So thank you.
Sure.
I guess it's possible if they're from out of state, if they're doing their internship, it's possible that their home state has adopted the movement early.
That's quite possible.
Yeah.
And they're just, yes. Hadn't actually thought about that, but that makes tons of sense.
David, you're going to ASPPB. Is that next month?
That should be, I believe, at the end of April.
Okay.
They have a mid-year meeting usually around that time period, and then an annual meeting at the end of the year.
So that might give, I mean, we might know how many states have moved up their consolidation of those two into one test.
Mm-hmm.
They may present that kind of information.
When you say consolidate, do you mean you'll take it at the same time?
No, they still would be taken separately, but
okay.
the way that it was described would be that if you continue to use the EPPP, it will essentially be EPPP Part 1 and EPPP Part 2 as one EPPP. So you'll still
Okay.
take them at separate times. There'll be a separate cost for each one, but it will be considered one test.
Okay. Thank you.
Abby, it's funny you would mention that because one of my students asked a very similar question yesterday. I don't know what's in the water, but
I don't know. I thought it was funny because they came back to back and they had not talked with one another about it. So it is funny that stuff just seems to spread somehow.
I wonder if there's something on a listserv.
It makes me curious, probably.
Okay. Any other topics that people want to put on the agenda, just generally to look at this year beyond a review of the education regulation? I guess we can use a similar process to what we did last year with the unprofessional conduct regulation. We can just go through it just to make sure as I understand it, and David, you can correct me if I'm wrong, that the goal is just to make sure that it's not necessarily to change anything, it's just to make sure that we've addressed it, to look at it, so that if the legislature were to ask, when the last time we've updated our regulations, we can say that it wasn't 20 years ago.
Yeah, I think that's part of it. Something also maybe to keep in mind too, I have heard discussion that in the past, certain requirements were very much based on courses. And from a licensing perspective, that's much easier for us to evaluate than, for example, equivalencies.
Mhm.
So from an applicant's perspective, I can see a real benefit in being able to demonstrate equivalency. But from a licensing body's perspective, we want to make sure that we're treating individuals as consistently as possible and making sure that we can review information and take care of licensing as quickly as possible. And so courses are really easy for us, at least much easier for us to look, to evaluate. And so if there was any change to move from a course based to more of an equivalency based, I would just ask the advisory committee to try to keep in mind how maybe some assistance for us to be able to evaluate some of those equivalencies too, to make sure that it doesn't create kind of a slowdown in the process of evaluating applicants or things like that.
Yeah. That'll be tricky. You know, there's the example from Texas. I don't know why they keep getting to be the example these days for things, but they've got some language in their regulations regarding program, how programs can demonstrate that they have trained competencies other than by coursework. And what I haven't figured out yet is how their state agency is able to assess that. So. Okay, well, maybe we can start looking at that in the April meeting. If there's other topics, maybe you can email those. If you come across anything, you can email those to David in the next week or two, and we can add those to the list. So I think that may take us down to item number 6. And I think, David, you've prepared some training for the boards for us.
Yes, and that training is fairly lengthy. So maybe it'd be better for us to briefly discuss that item B, the discussion of adding new members to the advisory committee. And then
Okay.
that way we can wrap up with the training, and should that go super long, we wouldn't have an issue with trying to squeeze that in at the end.
Okay, that seems reasonable.
So your advisory committee currently, including board members, has 10 members, and the advisory committee policy states that, there will be the members of the board from that profession that will serve on the advisory committee, and there will also be a public member. And then it states that the other voting members of the advisory committee would be between 3 and 10 non-board members that serve on the advisory committee. So right now, I believe you have 7. Now with 3 board members, it does create a little bit of an issue because with quorum, you need 6 members to make sure that you have quorum. So a lot of the advisory committees this time of year start to look to see, should you add more members to the advisory committee? And so right now, if you wanted to, you could add as many as 3 advisory committee members to that, to your committee. It is good to stagger individuals when they're coming onto the advisory committee so that not everybody comes up at the end of their terms all at once. But you certainly have a little bit of flexibility if you wanted to consider new individuals. And the process that has been used in the past is that if advisory committees decided they wanted to recommend adding more members, generally they would give direction to me to send out a message to all licensed applicants and indicate the advisory committee is interested in seeking individuals who wish to be added to the advisory committee, and provide a little bit of information about the criteria the advisory committee is looking for in terms of new members, which is described in the advisory committee policy. And it talks about having diversity based on geographic representation across the state, levels of licensure. It also mentions other factors in terms of advisory committee members. And actually, I'll just go ahead and read that section. So on the advisory committee policy, it says, in reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity, and that members should provide representation of the levels of licensing for the discipline, and those members should be selected from among the public and private practitioners and educators. So For individuals, when they submit materials, usually they submit a letter of interest and a resume, and what they choose to volunteer in that submission can be evaluated by the advisory committee members, but that discussion in terms of reviewing those applicants is done in an open meeting. So you review those materials, you have discussions. Usually it works the best when you review the materials and then you comment about which applicants stuck out to you the best, that you think would be good, best candidates to be added to the advisory committee. And then you have a discussion as far as that goes. But you do have some flexibility in this area. So that is what has been done in the past, at least most frequently. If you'd like me to follow a similar method, if you are interested in adding members, I could do that on your behalf. But you can have discussion about other options as well. So,
Do you know when our next board members are going to turn out? That might affect how many we would want to add in the course of a year if we know there are several going off. I know we've had that discussion, but I don't recall.
Sure. Yeah, I can go ahead and pull that up right now. I think Rick and I may have just talked about that just recently. But I mentioned there's 7 advisory committee members that are currently serving that are non-board members. And it looks like at the end of June 2024, Rodney McNeil would be coming off of the advisory committee because he's served 4 terms. There are 3 individuals who would be reaching the end of their 3rd term at the end of June of this year, but they would still be eligible to be reappointed for 1 more term. So nobody is coming off the board advisory committee at the end of June of this year, but there is 1 individual coming off at the end of next year. And then if they were reappointed, there would be 3 individuals coming off in 2 years, essentially.
Feels proactive to make some sort of effort to get in front of that, particularly if we're 2 years out of losing at least 3 people, if I understood that correctly.
Yes, there'd be one individual who would be coming off of the advisory committee in 1 year, and then 3 others that would be coming off the advisory committee in 2 years, assuming those individuals are reappointed to the advisory committee in July.
Right. Gotcha.
Mhm.
Seems prudent.
And we have openings for up to 3 more anyway. Is that correct?
That's correct. Currently, you have 7 individuals that are non-board members in the advisory committee, and you could have as many as 10 in that capacity.
Random question. What does it mean by levels of licensure?
For your profession, it really doesn't come into play. For
Okay, just
the other
checking.
professions, yeah.
I was like, I don't think we have that option, do we?
No.
Yeah, many of them have a clinical level and then a non-clinical
Yes.
level.
Yeah.
For social work, there's actually 4 types of license.
Yes, they're difficult to keep track of.
Yeah, there's still about 4 individuals who continue to renew their associate level social work license, but otherwise a bachelor's, master, and then clinical level. So for your profession, it's just 1. So
Okay,
that would be hard to incorporate.
just checking. I was like, could we add anybody that way? But no.
So it sounds like there's some enthusiasm for adding up to 3 new members.
Yes.
And do we also have the potential? I know that we had more applicants than we accepted last time. Is there any potential to specifically reach out to people who have applied but weren't added?
Yeah, that's something you could do as well. You could either consider those individuals who had applied in the past, or you could open it up to everyone again. And what I did for one of the other advisory committees, they wanted to open it up and have it sent out to everyone, but they wanted to know which of those individuals had already applied before. And so I basically submitted all of the names to the advisory committee, and I put a little star next to the ones that had requested to be considered during the last period, so they could see everyone and then see the ones that also had requested consideration during the last opening.
I like that approach.
Okay. So when we make that announcement, then we need to say we are considering adding up to 3, right? So then that doesn't box us in to selecting a particular number. Is that correct?
Yeah, it's hard to know who would apply and how many would apply. So you don't really need to say at this point how many you would want to add. You can wait, but if you want, I could say up to 3 in the message, but I don't have to include that either. I could just say they're looking to add new members and then,
Okay.
so.
Do we need a vote on that, a motion and a vote, or do we do this by consensus?
You could do it by consensus. If there's no objection, then I can just take it as the consensus of the advisory committee to move forward on that and send out a letter or basically an email to all licensees, let them know that if they want to be considered, they could apply, and I'll include the advisory committee policy so they have an understanding of what the advisory committee's responsibilities are. And then I will go ahead and stress those factors that I mentioned as well that are included in the advisory committee, so they know that the advisory committee is going to be looking at certain characteristics specifically when they review candidates.
Okay. It sounds like a plan.
Okay, I will go ahead and send that out, and I will give you an update at the next meeting. If we have all those applicants ready, you could discuss them at the next meeting, or you could take care of that either at the, I guess, the April meeting or at the June meeting, but you could definitely begin them at the April meeting. I'll try to have that all arranged and ready for you guys.
Sounds good. Thank you.
Right.
So then, do you want to launch into your training?
Yes, I'll go ahead and do that. And so annually, we provide a training for advisory committees, and this also includes training for board members at the same time. And so I provided some documents in your packet of material. There's 3 paper documents, and then I'll be talking to some other general responsibilities for board members and advisory committee members. And so the 3 documents you have are 3 policies. One is called the expectations of board members. The second is the advisory committee policy. And then the third document is a document that was designed to provide guidance to public attendees of meetings. So the training should follow those and then some additional information. So I will go ahead and share my screen here, and then we can walk through, try to incorporate some of this information into a PowerPoint this year. Okay. Can you all see my screen now? Great. Okay. Well, this is the training for advisory committee members and board members for 2023. The BSRB mission, in accordance with the intent of the Kansas legislature, is to protect and serve the consumers of services offered by BSRB licensees through the issuance of licenses, resolution of complaints, and creation of appropriate regulations accomplished through efficiency, fairness, and respect to all those involved. And so one of the things that I always feel is helpful to reiterate is the mission of board members and advisory committee members is to keep in mind that the overall mission of the agency is to make sure that we are protecting and serving the consumers of services that are offered by those licensees. A little bit of the history of the BSRB. The agency was created in 1980 by the Kansas legislature. They combined the existing psychology, board of psychology examiners and social work examiners into one board. Additionally, a little bit of the history of the BSRB. Over the years, the BSRB's jurisdiction was expanded to include the licensure of professional counseling, master's level psychology, marriage and family therapy, addiction counselors, and behavior analysts. The board is a composite board, and rather than have a separate board for psychologists, social workers, professional counselors, etc., the board is one board. And so there are members of the different professions as well as members of the public, and that is called a composite board in many other states. Some of the benefits of having a composite board is that by using that model, the agency saves a significant amount on operational expenditures by sharing resources and utilizing licensing and investigative staff for similar subject areas. One of the differences between the BSRB operating as a regulatory board versus an association is that we exist to protect consumers. We are created by the legislature. We are governed by statute, whereas an association may have similar interests at times and similar goals, but it exists to enhance the profession in a lot of cases and is created by the profession. In terms of our staff that support the work of the board, we have 10 staff members, including myself, the assistant director and licensing manager. We have licensing specialists, investigators, and also clerical employees. In terms of our operations, the BSRB is a fee-funded agency, so we do not receive funding from the State General Fund. But by statute, we contribute 10% of revenue up to $100,000 per year, and that goes to the State General Fund for the main operations of the state. Our agency revenue is primarily from license fees. Our annual budget for the agency is about $1 million. And as a small agency, the BSRB contracts with and has agreements with many other agencies. In terms of the board members are all appointed by the governor to serve 4-year terms and may be reappointed for a second term, allowing for service on the board for a maximum of 8 consecutive years. The board composition is as follows: 2 psychologists, 2 social workers, a marriage and family therapist, a professional counselor, an addiction counselor, a master's level psychologist, and 4 public members. As I mentioned earlier, the board requested statutory language to change the composition of the board to add a member for the behavior analyst profession, but that would make the board 13 members. Currently, there are 12. In terms of the functions of the BSRB, there's 2 main functions: licensing and investigation of complaints or discipline against practitioners. Currently, there are about 14,779 active permanent licensees under the board, and they are broken out into those 7 professions that are listed there. You're more familiar with some of these acronyms, but this lists the current number of individuals that are licensed in each of those levels for each of the professions. If you're interested in looking at this information a little more closely, this is also included in a packet of material that we provide for the board at each full board meeting. And so you can see a history of those licenses. If you go to the website and look at the board meeting from January 6th, you can also see this in a table form. In terms of new licenses, and last fiscal year, the state fiscal year runs from July 1st to June 30th. The BSRB issued 1,536 permanent licenses, 328 temporary licenses, and 97 out-of-state permits, and 4 provisional licenses. Of the 1,536 permanent licenses issued by the board, 1,112 were initial licenses, and 424 were reciprocity. In terms of our renewals and audit responsibilities, last fiscal year, we processed 6,214 license renewals. And as part of the license renewal process, 10% of all applicants are audited to ensure they have met the continuing education requirements. In last fiscal year, the BSRB audited 625 individuals. In terms of licensing trends, since July of 2015, the number of permanent licensees has increased by 21.6%. From 12,152 to 14,779. The professions with the largest increases are professional counseling, social work, and also behavior analysis. I've mentioned a little bit about licensing, but the board also oversees investigation of complaints and discipline against practitioners. The agency has administrative authority over practitioners, but this does not take the place of criminal proceedings or civil proceedings. Those are separate. So while we do take complaints against practitioners, if there are matters that are more of a criminal nature, we inform the individual they may want to contact law enforcement, or we refer that matter ourselves if it is something urgent. Or if there is a matter where it sounds like it's more of a matter of a civil proceeding, we never encourage someone to sue someone or not to sue them, but we try to clarify that our jurisdiction is administrative authority involving the agency and the license of a practitioner. This is not a proceeding where the person would have the complaint against the person and it's those 2 parties. It's more of they refer the complaint to us, we investigate it, and then it has to do with the board ensuring that we're protecting the public by investigating that and determining if there was any violation of unprofessional conduct or other statutes. In terms of complaints, last fiscal year, we received 205 complaints or reports of alleged violation against practitioners. And for comparison, practitioners received about 130 complaints in 2021, 190 complaints in 2020, and about 200 complaints in 2019. And you may wonder why there was that dip of complaints in 2021. And I honestly don't have a good explanation for that, except to say that in talking with other states, they similarly saw a decrease, and that was during some of the initial stages of the pandemic. And so I think it was related somewhat to the pandemic and maybe the change in services individuals were receiving, or maybe the lack of services some individuals were receiving if they were used to only receiving in-person services. But I can tell you that as we have moved forward, the rate of complaints we've received against practitioners has returned to the pre-pandemic levels. In terms of the investigative process we use, complaints are reviewed to determine whether the BSRB has jurisdiction over an issue and whether the matter involves a potential violation of the statutes and regulations for the profession. For complaints or RAVs, they are reviewed by a subset of the board, the Complaint Review Committee. Common violations that we see include falsifying continuing education requirements, such as audit violations, practicing without a license or an expired license, having a dual relationship or a conflict of interest, making sexual advances towards or engaging in physical intimacies with any client, refusing to report termination or suspension, confidentiality violations, or practice issues. And those could result or they could connect to performing services inconsistent with one's education or accepted professional standards. In terms of outreach, the executive director, myself, and the assistant director and licensing manager for the BSRB, we speak with groups of students to provide information on licensing and disciplinary matters to provide a proactive approach to assist individuals before they become licensed. And last fiscal year, we provided 18 presentations to different groups of students. Additionally, as you are familiar with, we launched a YouTube channel back in January of 2021. That is for us to be able to broadcast our board meetings and advisory committee meetings. Since that time, we have broadcast 97 board meetings or advisory committee meetings, or have uploaded them after those meetings. They have been viewed over 3,000 times. And then I included a link there for individuals to be able to access our YouTube channel if they want to use that link. Additionally, on the website, we let individuals know that there's other materials that are available. ksbsrb.ks.gov. The website also offers a portal for individuals to renew their licenses. It offers copies of forms and other applicant materials, statutes and regulations, proposed changes to the statutes and regulations, complaints or reports of alleged violation forms for individual to fill out if they do have a complaint against a practitioner. They could also review disciplinary orders if there are violations of the statutes, and those have become final actions that involve practice. Those are posted on the BSRB website. And additionally, there's information on board and advisory committee meetings, such as the agenda and other materials that's posted for the meetings. In terms of those documents I referenced, I think it's really helpful for you all as advisory committee members to know how your role fits within the greater scheme of the agency and also the board itself. So there's an expectations for board members policy that's posted on the website. It does clarify that insofar as the expectations for board members conflicts with or limits any federal or state statute or regulation, the statute or regulation controls. So while the policy on expectations for board members is important, it does come after any requirements in state law or federal law or the regulations for the profession. Guiding principles. So persons in Kansas shall expect that qualified mental health providers are qualified, competent, and professional. And also persons regulated by the BSRB shall expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulations. The BSRB shall provide all services in a manner that is timely, cost-efficient, courteous, and competent. The BSRB shall be guided and led by ethical principles, clear policies, progressive thinking, and strategic decision-making, and the BSRB shall respect the dignity and worth of all individuals. In terms of the services that are listed under that expectations of board members, the BSRB services include processing license applications and license renewals in a timely manner, taking disciplinary action when appropriate, providing timely information to the public, and maintaining rules and regulations and statutes. Concerning the code of conduct for board members, they are asked to follow standards of integrity. A board member of the BSRB should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. A board member of the BSRB possesses sound moral principles, is upright, honest, and sincere. A board member of the BSRB has courage of convictions to withstand pressures to be swayed from the public protection agenda. And a board member of the BSRB shall be honest about personal agendas and leaves them outside of the boardroom. Also, a board member of the BSRB should reveal any actual or perceived conflicts of interest and appropriately recuse themselves from decisions or actions in those areas of interest. A board member of the BSRB should not represent their personal opinion as that of the board. And a board member of the BSRB shall be limited to one unexcused absence a year. Concerning the expectations of board members document, when it speaks to conflicts of interest, it says that a board member for the BSRB should guard against conflicts of interest. And under compliance, it notes that common components of conflicts of interest policy include, but are not limited to, that the board member of the BSRB should have no personal financial benefit as a result of service to the BSRB, except for subsistence and mileage and other reimbursements under the state law. A board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. A board member of the BSRB should disclose any relationship with any other agency or individual involved with the BSRB and be excluded from matters involving such a conflict. A board member of the BSRB serving as part of the organization working in any way with the BSRB should inform the board chair. A board member of the BSRB should not accept any gifts or promotional items received as part of their affiliation with the agency for personal use. A board member of the BSRB should not use the agency's name or agency information for personal gain. Concerning confidentiality, the board discussion involving any of the following matters shall remain confidential unless the board expressly agrees to the contrary. 1, any discussion that occurs during an executive session, and 2, any discussion concerning actual or potential litigation. In terms of the board chair authority, the chair of the board shall preside at all meetings, appoint members of the advisory committees, appoint members of the CRC, and appoint members to other ad hoc committees. The authority of the vice chair shall discharge the duties of the chair in his or her absence, disability, resignation, or death. In the event that the executive director is unable to perform the duties of office of executive director, the BSRB may request an interim director. And if the BSRB is unable to meet immediately, the board chair will serve as interim director until the board can meet. In terms of the relationship between the board and the executive director, the organizational structure is that the executive director will communicate personnel matters that should be addressed by the board to the chair of the board. The chair of the board will present these board-related issues to the board, and the executive director will communicate to the staff of the board wishes, intentions, and policies. Additionally, there are some delegations from the board to the executive director. The executive director shall be the administrative head of the organization, serve at all times under the board. The executive director will be responsible for implementing and executing the policies and activities approved by the board. He shall assist in the development of overall program and shall recommend policies and activities for consideration by the board. Secondly, the executive director shall have the sole authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to the policies, regulations, and limitations approved by the state of Kansas. And just for your benefit to know, in terms of our own staff here, the legislature every year when they review our budget, they review how many individuals are employed by the BSRB. And should we want to hire additional employees or change the amount that any employees are paid, that does have to go in front of the governor's office, and they have the ability to limit our ability to hire employees or to approve a certain salary for employees. So any of those personnel decisions have to be sent through the governor's office as well. In terms of the executive expectations, the executive director shall keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information. The executive director shall prepare the agenda for board meetings in consultation with the board chair. And also the executive director shall prepare the agenda in consultation with the board chair for an annual board retreat, which shall allow for issues before the board that need an in-depth consideration. And last year that all-day meeting or the retreat did occur in October of last year. The expectations of board members policy does talk about monitoring the executive director's performance. It states that the board shall, when necessary, utilize an executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis on whether set outcomes are attained. And so this does call for a performance evaluation of the executive director every year. And so that's what the expectations of board members document kind of frames in terms of the role of the BSRB, the expectations for board members, and also some of the information concerning individuals such as myself, the executive director, and the staff of the board. Concerning the advisory committees, to assist the work of the board utilizes 7 standing advisory committees. These are for each of the 7 professions regulated by the board. The advisory committee policy is posted to the board's website. And currently, when you take out the members of the board that serve on the advisory committees, there are 55 other individuals who volunteer to serve on those advisory committees for the board. In terms of the advisory committee policy, the advisory committee purpose states that a BSRB advisory committee, as a creation of the board, has the purpose of supporting the board in carrying out its mission to protect the public. Members serve at the pleasure of the board, and actions relating to informing, licensing, and disciplining of those persons regulated by the board are the methods for accomplishing that mission. An advisory committee fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. And a committee may suggest issues it believes the board should consider, referring those through the chair of the advisory committee. In terms of the board's responsibilities, when those items are referred back to the board has 3 options. 1, it can agree the issue needs to be addressed at the board level. 2, agree the issue should be addressed and refer the matter to the appropriate person or committee for additional information, review, or analysis, which will then be brought back to the board, or the board could decide not to address the issue. In terms of the structure of the advisory committee, chairs of the advisory committees will be members of the board. If the profession is represented on the board, the chair of the advisory committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent that discipline on the board. Currently, all of the professions regulated by the BSRB have a board member, except for the behavior analyst profession, and currently the board member for master's level psychology serves as the chair of that advisory committee. This advisory committee policy states that any other board members appointed by the governor to represent that discipline on the board will serve as members of that advisory committee. A public member of the board will also be a member, and there will be a minimum of 3 and a maximum of 10 additional members appointed. The executive director will be a non-voting ex officio member, and the assistant director or licensing manager is encouraged to attend those advisory committee meetings. The assistant attorney general representing the board should attend the meetings when their attendance is requested. And so when the board meets next, we will have the advisory committee policy modified to reflect that that should be the legal counsel for the board going forward. Structure of the committee. Terms of it for advisory committee members will be 2 years, and they will be appointed by the chair of the BSRB and can serve up to 4 terms. So essentially, board members can serve 2 4-year terms for a total of 8 years. Advisory committee members are appointed for 2-year terms, but they can serve a total of 4. So essentially, it's the same 8 years, but broken out separately. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. And then a very, very, very important phrase in the advisory committee policy, and part of the reason why I walked through the expectations of board members document. There is language in the advisory committee policy that states the policies and procedures under which the BSRB board members are expected to operate will apply also to the advisory committee members. So while the advisory committee policy is much shorter than the expectations for board members document, it's really important that you understand the policies and procedures of the board members because of this language here that states that those policies and procedures under which the board operates are also expected to apply to the advisory committee members when that's applicable. The chair of the board can also remove members, so the ability to add members officially is under the chair of the board, and the chair of the board has the authority to remove members from the advisory committees as well. In terms of selection of advisory committee members, members for the committee may be nominated by anyone, including the public. Committee members of a professional organization, either through the discipline's own or others, or through self-nomination. In reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity. Members should provide representation of the levels of licensing for the discipline, and those members should be selected from among public and private practitioners and educators. The committee as a whole discusses nominations and reaches recommendations on new members. The nominee's resume, a letter stating the reasons why he or she desires to be appointed, and a copy of the board's mission and goals to which the nominee has indicated agreement are reviewed. The chair of the committee will submit the chair's recommendations for new members to the BSRB board, and the chair will review the recommendations and may request input before making a decision, which will be announced at a board meeting. And so the authority of the advisory committee is to discuss those individuals and to submit recommendations. And on behalf of the advisory committee, what I do is I draft a letter summarizing the discussions that took place at the advisory committee, the recommended individuals the advisory committee has recommended be added, and then I submit that to the chair of the board. And then if the chair of the board requests further information, I work with the chair to get that information. And ultimately, the members the chair of the board decides should be appointed are officially appointed at a board meeting, after which time I follow up with the members of the advisory committee that have been appointed and make sure they have all the information they need for their first initial meetings. Now, I mentioned that there was a third document, and that includes guidelines for attendees of meetings. That is an official policy posted to our website. It clarifies that public comment is not entitled to individuals, but it could be approved by the chair. It outlines the process and the processes that should be followed during comments to the board or advisory committees and topics relevant for public comment to the board or advisory committees. It clarifies that the board wants to receive complaints against practitioners and provides information on how those complaints are to be submitted, but informs potential attendees that certain matters concerning specific licensees will be considered in a closed, standardized process to ensure fairness to members of the public and licensees. And so those are the three separate policies that are posted to the BSRB website. There's also some information that concerns individuals serving on regulatory boards or in positions like this that I thought was also really helpful for you to receive. So I'll go through some of that, and I'll talk about some of the information that's included in the statutes and regulations for the professions. And I'll touch upon topics like the Kansas Open Meeting Act, Kansas Open Records Act, and the Kansas Administrative Procedures Act. So for professional licensing board, the state of Kansas regulates many professions, and each of these professions is regulated by a licensing board or commission that was created by the Kansas legislature for the purpose of ensuring that licensed professionals are competent and do not pose a risk to the public. A professional licensing board is created by enabling legislation, which establishes a board form, mission, powers, functions, tools, implementation, and enforcement abilities. The board is considered a creature of statute, meaning the board's power is dependent upon its authorized statutes, and therefore any exercise of authority claimed by the board must come from those statutes, either explicitly or necessarily implied. A board can administer, implement, and enforce only those statutes. And if those statutes are silent on a particular action, the board's authority to take such action, simply put, a board can only do what the statutes say that the board can do. Besides the statutes specific to a board's authority is limited by the constitutional equal protection and due process rights, which can prohibit a board from acting in a manner which result in disparate or inconsistent treatment of persons similarly situated, from adopting different standards for similar situations, or otherwise acting arbitrarily, capricious, or vindictively. For example, the licensing board may not impose more severe discipline on male licensees because of their gender, or a licensing board may not revoke a license simply because the board does not like that particular licensee. Other constitutional guarantees, such as freedom of speech, right to privacy, unreasonable search and seizures, and vagueness also establish parameters on the board's authority. In terms of the legislative authority over the BSRB, the Kansas legislature did create the board and retains control over certain aspects of a licensing board, such as modifying the enabling legislation, which would change the purpose of the board. They could limit expenditures for the agency in an appropriations bill, which could severely limit our ability to do operations on a day-to-day basis. They could enact new legislation to change the makeup of the board, the scope of the powers, or anything else related to the board. In order to carry out its purpose, the board is granted or delegated powers and functions parallel to the three branches of government: executive, judicial, and legislative. The executive authority the board has is to carry out its enabling act. It also follows the Kansas Open Meeting Act at times and the Kansas Open Records Act. In terms of the judicial authority the board has quasi-judicial authority when it has hearings and reviewing facts when violations of the law have occurred. And it also follows the Kansas Administrative Procedures Act for different processes when appropriate. And then in terms of the legislative authority for the agency, that would be essentially administrative authority. The agency has the ability to adopt regulations to implement or interpret the enabling act with more detailed or specific requirements. And this process also involves holding an open hearing on proposed regulations, allowing feedback, and there is also oversight by a legislative committee on that process. In terms of the statutes, regulations, and policy, in order to fulfill its responsibility to protect the public from incompetent, unprofessional, and unauthorized practitioners, a regulatory board implements and enforces statutes and regulations, and at times operates according to internal policies. In order to be effective, board members need to understand the difference between statutes, regulations, and policies. In terms of statutes, statutes are laws passed by the Kansas legislature through the authority derived from the Kansas Constitution and subsequently signed into law by the governor. The statutes generally become effective on July 1st of that session year, but can become effective if a different state is specified in the legislation. And then those statutes set the parameters of the board's responsibility and authority. Statutes control any inconsistent regulation or policy. If a board becomes dissatisfied with the scope of its authority, the board must seek legislation to obtain its goal. The regulations are different. Regulations are adopted by a board to further implement or carry out the purpose of a particular statute, and a board's authority to adopt regulations is derived directly from the statute. And so in adopting rules and regulations, a board follows the Rules and Regulations Filing Act to ensure the process for adopting regulations is open, receptive to the public and legislative input, addresses the economic impact of board and those affected, and the regulations themselves are consistent in style, organization, and grammar, are lawful, and are filed and published. Regulations are also promulgated to complete and fill in details of a statutory scheme, implementing statutes, and affect rights and responsibilities of third parties outside of the board. And when adopted in accordance with the Rules and Regulations Filing Act, regulations do have the force and effect of law. They are essentially legally enforceable. To be valid, a regulation must be within the statutory authority conferred upon the board to implement a specific statute and otherwise pass the test of legality. Any regulation that goes beyond the authority granted violates the enabling statute or is inconsistent with the statutory power of the board, another statute, or the Constitution, finds that the issue would be voided. We've talked about statutes that provide the framework, policy, or regulations that allow us to flesh out the details within that statutory authority. And then in terms of policies, policies also provide a role to the agency. They can be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. Guidance documents are documents that state a board's current approach to or interpretation of law, or general statements of policy that describe how and when the board will exercise its discretionary functions. I think it's important for you to have a little bit of information on how to be an effective board member or an effective advisory committee member. What I would recommend is that, as time allows, read the board's enabling statutes, and they are listed right there. Read the board's licensing acts, especially the licensing act specific to your profession, and then read the regulations for each licensing act. And then also on our website, I mentioned our policies are posted, so become familiar with the policies the BSRB has listed on our website. Be on alert for agency policies and internal procedures, which may be inconsistent with or conflict with board statutes or regulations, or which affect requirements for applicants or licensees. And be willing to initiate action to amend statutes or modify regulations. So we encourage you to look through those documents. If you see something and you have a question about it, feel free to reach out to us and ask us. There may be a reason why something is worded a certain way or a reason why something is included, and we'd be happy to talk to you more about those items. If a statute or regulation seems confusing or vague, it could appear that way to individuals who must comply with them. So remember, the purpose of imposing discipline against a licensee is to encourage compliance with the law and protect the public. Discipline should not be vindictive or disproportionate to the severity of the violations. Always be mindful that the role of the board is to protect the public and not the licensees. A little bit more on conflict of interest broadly. Conflict of interest typically means having an interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or incurring any obligation of any nature which is in substantial conflict with the proper discharge of the board member's duties in the public interest. Board members or advisory committee members must make public and recuse themselves from any conflict of interest that exists to ensure the integrity of the board and all of its decisions. Disclosures and recusals are important tools to avoid actual or perceived conflicts of interest, but board members should not overuse recusals as an excuse to avoid conflict in exercising their full responsibilities. Personal conflicts are those actions that may ultimately have a personal consequence and a direct or indirect effect on a decision or action. No decisions should be made that advance the personal benefits of the board member. Some examples of personal conflicts include personal gain, bias, or effects on a personal relationship. And concerning confidentiality, at all times, a board member or advisory committee member must conform to the rules of confidentiality in dealings outside the boardroom or outside of this type of forum as well. Protected information obtained in the capacity of a board member must remain confidential during and after the board membership. Termination of board membership does not dissolve the board member from responsibility. The rules that apply during active board membership continue to apply after termination of board membership, and confidentiality must be maintained on all confidential subjects that the individual was privy to as a board member. Some examples of times when confidential information could potentially be discussed. If you have an executive session, which occurs during an open meeting, or you have deliberations, for example, after a hearing, the Kansas Open Meeting Act, or KOMA, and the Kansas Administrative Procedures Act, or CAPA, allow the board to deliberate in private in order to reach a decision on a particular case involving a specific individual. We do get questions from time to time from board members or advisory committee members who have membership in different professional activities. So there's a note here that says a board member may hold an office in a professional or trade association of the regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member may not use her position on the board to further the interest of the professional association or his or her office in that association. Board members may attend professional conferences and social events, but they must be mindful of open meeting rules and conflicts of interest, and we'll get into that a little bit more concerning what to be mindful of in terms of those open meetings. If a majority of board members are present, do not discuss the business or affairs of the board to avoid a triggering of a meeting under the KOMA. Additionally, do not discuss matters related to a particular pending application or a disciplinary matter. A board member should not represent himself or herself as a spokesperson for the board unless authorized by the vote of the board to speak on the board's behalf. If the board member is asked to give the board's position on an issue and the board has not authorized the member to do so, the board member must decline to comment or make clear that any opinions expressed are those of him or her alone and not the board. A board member should not ask board staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. And so in terms of not speaking on behalf of the board provides authority to me to at times offer testimony, for example, in support of the BSRB bill, or after the board meeting tomorrow, the board could provide direction at that meeting for me to introduce testimony on any of those bills that are being considered by the board. And board members could voice their own opinion on something, but you want to be careful not to give the impression that your own individual comments are that of the board. And so in general, if someone asks what the board would do in a future situation, it's best to avoid responses like that. It's okay to talk about what the board has done in the past, and it's okay to reference items that individuals could go and watch or look at from our meetings that are broadcast. So you can always go back and see what has been discussed and what the board has taken action on. It usually gets into a little bit of a situation if someone asks about a future opinion on what the board may or may not do. So just be mindful of that if that ever comes up. In terms of the Kansas Open Meeting Act, also known as COMA, it allows the public to observe governmental entities making decisions. Meetings shall be open to the public because a representative government is dependent upon an informed electorate according to the statute. Because the purpose of COMA is to benefit the public, it is interpreted liberally and exceptions are applied narrowly to carry out its purpose. The COMA applies to all legislative and administrative bodies and agencies of the state and other subordinate groups thereof, receiving or expending and supported in or in part by public funds. COMA does not define the term subordinate groups, but if created by a covered entity of the group that has become an extension of the covered entity, most likely the subordinate group is subject to COMA. And why that's referenced here is because one of the groups would be the Behavioral Sciences Regulatory Board for board meetings. And then the advisory committee is a subordinate group of the board. COMA should apply to the meetings of the advisory committees as well, which is why we make such efforts we do to make sure the meetings are public and individuals from the public can have access to all this information. The COMA does not apply to an otherwise covered entity when exercising a quasi-judicial function or conducting a proceeding or hearing under the Kansas Administrative Procedures Act. And it also does not apply to judiciary, private organizations, and staff meetings of a covered entity. A meeting is defined as any gathering or assembly in person or through the use of a telephone or other media for interactive communication by a majority of the membership of an agency or public body subject to the act for the purposes of discussing the business affairs of the public body or agency. So there are different elements to evaluate if something is actually a meeting, but essentially you're looking for that. You're looking at, is the majority of the membership of a body present? Is it for the purposes of discussing the business or affairs of the public body? And then it doesn't have to be just a gathering in person. It could be a gathering of everyone on the phone, or it could be over Zoom like this. And so you have to be mindful of what would constitute a meeting. So as it mentions here, they could be conducted by telephone or other electronic means such as Zoom, Skype, Teams. The board complies with all COMA requirements. A meeting includes informal discussions before or after the public meeting, during a recess of a public meeting, and all gatherings at all stages of the decision-making process. The name of the gathering is irrelevant, thus work sessions or retreat are subject to COMA. As you may recall, the board's meeting in October was an open meeting, and we did have individuals from the public attend that meeting as well. So those meetings are still under COMA and they are still public meetings. A discussion does not have to require binding action or voting. A discussion can occur at social gatherings, retreats, and meetings held in private, education, conferences / seminars. The traveling to such meetings and members of the board should avoid discussing business and affairs of the agency, specifically when it involves having the majority of members present and you're not in an open forum to avoid any issues with discussion. The presiding officer has the duty to provide notice of the meeting, but this duty is usually delegated. So here at the BSRB, we take care of making sure that all the public notice for meetings is taken care of. The COMA does not require notice of meetings to be published in the newspaper or other form of paper or on a website, but an individual must request notice of meetings, and there are no formalities to requesting notice. It can be verbal or written, and we do have a list of individuals who have requested public notice for meetings, so they receive information when meetings are scheduled or when there are changes. The notice must provide the date, time, and location where the body will meet to the person requesting the notice in a reasonable time before the meeting, and a request is valid for 1 fiscal year. The board must notify a requester of expiration before terminating the notice to that requester. The COMA does not address meeting procedures. A board is not required to follow Robert's Rules of Order or any specific formal rules of procedure. So as you may notice, sometimes we vote on certain issues and other times we can accept consensus. And so there are specific instances that are required to be, for example, a roll call vote when the board is taking final action to approve recommendations before they officially are implemented. That is required to be something where you need a roll call vote on the record. And then it does talk about there's certain language that says you cannot have a secret ballot, but in terms of using a specific voting procedure, you don't have to follow a specific voting procedure. It doesn't require the board to create an agenda, but if one exists, it must be made available to everyone. Person may record the meeting if doing so is not disruptive, and the public does not have the right to speak, but only to listen and observe, and the board cannot vote, as I mentioned, by secret ballot. A board policy may require minutes to be kept, but the COMA does not require the board to have minutes unless there is a motion to go into executive session. The motion as made must be included in the minutes. An executive session permits discussion of certain enumerated matters outside of public view. To take an executive session, the board must first convene an open meeting. The board cannot take binding action in executive session, but the consensus is allowed. If a consensus is achieved, then the board must reconvene the open meeting and take a formal vote in an open session. Just to let you know, any kind of violations of the COMA, our prosecutions under the COMA are civil, not criminal. Any person, such as a county district attorney or the attorney general, may bring an action in district court. County or district attorney or the attorney general has subpoena power, and enforcement actions take precedence over any other case and are assigned for trial at the earliest practicable date. The remedies for a COMA violation include voiding any action taken if prosecuted by the attorney general or other attorney only, and an injunction stopping the action, mandamus, which is forcing the action, or a declaratory judgment. The penalties for a COMA violation include a fine up to $500 per board member, not the board itself, for each violation, ouster from office, recall from office, court costs associated with the person seeking enforcement of COMA, court costs assessed against the plaintiff if maintained action frivolously, not in good faith, or without a reasonable basis in law. So some of these reasons are why we take such measures we do to make sure there's adequate notice of meetings and that we're following things in an open format. There's also the Kansas Open Record Act, or KORA, which requires the board to have records, quote, open for inspection by any person unless otherwise provided. And KORA shall be liberally construed and applied to promote such policies. A public agency such as the BSRB includes the state or any political or taxing subdivision of the state, or any office, officer, agency, or instrumentality thereof, or any other entity receiving, expending, or supporting in any whole or in part public funds appropriated by the state or political taxing subdivision, and the term instrumentality is not defined in KORA. Nevertheless, when created by a covered entity such as the BSRB, the group has become an extension of a covered entity. It is most likely to be covered as a public agency, and it does not include private companies, even if they receive public funds in exchange for goods and services. So basically, a public record includes any recorded information, regardless of form or characteristics, which is made, maintained, or kept, or is in the possession of any public agency, or written records, photographs, computer data, and email. A public record does not include records that are owned by a private person or entity and are not related to functions, activities, programs, or operations funded by the public funds, or records not in existence at the time of the request. The board is not required to create records in order to fulfill a request. Under the KORA, the board must appoint a Freedom of Information Officer to assist with KORA requests for the BSRB. That is Leslie Allen, the Assistant Director and Licensing Manager. We display, distribute, or otherwise make available a brochure describing the requester rights, agency responsibilities, and procedures for inspecting or obtaining copies of public records, which we do. And we include the name and title of the records custodian, fees, and hours available for anyone to make such a request under KORA. In Kansas, any person may make a request, and the person need not be a resident or provide reason for their request. The board may require the request to be in writing, state and the address of the requester, provide proof, identification, and sign a written certification that the requester will not use the names and addresses obtained from the records to solicit sales or services. Unless closed by law, the board cannot deny the person the right to review its public records. For instance, copyrighted material may not be reproduced without the permission from the copyright holder, but must be available for viewing or listening. If portions of the record are closed, the remainder of the record must be made available to the requester. And this reference is known as redaction. So there are certain records we have that if they were requested by a proper request under Cora, we would have to provide those records, but there may be certain information within those records that would be privileged or confidential that would have to be redacted. The board is not required to make copies of recordings or tapes or discs, videotapes or film, pictures, slides, graphics, illustrations, unless shown at a public meeting. And the request must be acted upon as soon as possible, but not later than the end of the third business day following the date the request was received by the board. 3 responses are acceptable. 1, the request is provided in the form requested if possible. The request is under review and the records, if permitted, will follow. And 3, the request is denied with a detailed explanation for the denial. That does not mean that the records always have to be provided within 3 days, but you do have to submit a response letter back, either seeking one of the clarifications or providing the records if they are available. But you do need to act upon an open records request under the Cora within 3 days. Under the Cora, there's a presumption of openness. As such, the requested public records must be released unless there is an exception to disclosure applies. The burden rests on the board to prove the requested records are exempt from disclosure. Exemptions to disclosure may be discretionary or mandatory. The Cora is a civil act, not a criminal act. Any person or a county district attorney or attorney general may bring civil prosecution. And then it mentions those individuals have subpoena power. Such actions are assigned a trial date at the earliest practical date, and the district attorney may review the requested records in camera. The important thing for your purposes is that there is certain information that is communicated to you on behalf of the agency. You want to make sure that if there are items that you want to work on involving the board, it's always helpful to include me on those conversations with items such as letters or emails, because that way the board has a record of those documents. So if we receive a request, we can provide those documents unless there's something that has to be redacted. But if you work on items related to the BSRB and they are outside of our server or outside of our records, then potentially Kansas Open Records Request Act request could apply to some of those communications from you. And so we would have to let you know about those, or if you receive those from someone else, be sure to inform us so we can assist you with any Cora request you may receive as relates to your responsibilities with the BSRB. And actions brought by those attorneys, there could be fines up to $500 per violation that can be imposed for knowingly violating or intentionally failing to furnish information. Cost or reasonable attorney fees, including appeals, may be imposed if the board's denial is not made in good faith and without a reasonable basis in fact or law. And so that is the Cora. So you have a little bit of information now about the COMA and a little information about the Cora. And the last act is the CAPA, and that's the Kansas Administrative Procedures Act. The CAPA creates only procedural rights and imposes only procedural duties. The CAPA does not provide substantive law. Those laws are governed by the board's Enabling Act and Licensing Acts. And the CAPA applies only to the extent that other statutes expressly provide the provisions of the CAPA govern those provisions. The general rule is that licensing boards like the BSRB must do business in an open meeting under the COMA unless directed by statute to conduct the proceeding or hearing pursuant to the CAPA. And so those two acts are mutually exclusive. When a licensing board statutes provide the CAPA applies to certain decisions, the board shall follow the CAPA, not the COMA, when making those decisions. The CAPA sets out a procedure to follow when the board is deciding what to do in cases such as individual licensees, much like a procedure that is followed in court cases. In those types of cases, the board is conducting a quasi-judicial function in deciding the outcome of the case. When CAPA applies, none of the stages of a particular case has to be open to the public observation other than a hearing. Also under CAPA, each of the board's licensing acts has a CAPA provision. Under the CAPA, neither the public nor the applicant has to be notified when the board meets to consider an application for licensure. Similar, under the CAPA, neither the public nor the licensee has to be notified when the Complaint Review Committee or the CRC meets to consider whether probable cause exists in a disciplinary case to issue a summary proceeding order. Additionally, the board and the CRC do not need to take a vote in public for decisions to be made under the CAPA. Under the CAPA, decisions are made when the license or an order is issued. The necessary board staff or the board's and CRC's attorney can be present during the CAPA discussions to make sure the board members have the information or legal advice they need to make an informed decision. Also under CAPA, there are some board activities that are not covered by the CAPA, and these must be acted on in an open meeting under the COMA. Those activities that are specifically public activities are approving board minutes, discussing and voting to approve any amendment to regulations or guidance documents, or delegating authority to a board member or the executive director for a particular action. Additionally, other public actions that have to be done in an open meeting would be receiving agency updates regarding the budget, legislation, statistics on a complaint, NCRC activity, education, and the executive director's report. Decisions whether to renew contracts or change the way contract services are provided, and policy decisions affecting the way the board operates internally. Concerning applicants for licensure, a person who files an application for licensure has the burden of proof. The staff will gather the information submitted by an applicant for the board's consideration to determine whether the applicant is qualified for licensure or whether a license may be conditioned or restricted. If the board denies conditions or restricts a license, an applicant may request a hearing, and the applicant did not agree to such an action, a consent agreement in order. Under the investigations for the board has the burden of proof to show that a licensee has violated a statute or regulation. All licensing boards can investigate complaints or allegations that a licensee has violated its statutes or regulations. The board's investigator generally gathers information and then presents that information to the CRC of the board. The CRC reviews the information to determine whether there's probable cause or reasonable grounds to believe that the licensee has violated specific statutes or regulations. And this means information that would lead to a reasonable, prudent person to believe that the licensee violated one of the board's statutes or regulations. And then when making a determination, the CRC must make sure that the conduct that the licensee is accused of actually violates one of the board's statutes or regulations. The fact that the licensee did something that made someone angry or violated a professional association's ethical code or did not follow an employer's policy does not necessarily mean that the licensee violated a statute or regulation. Further, the licensee can request a hearing on the summary proceeding order within a certain prescribed time period, and that's defined by statute. Once a petition or request for a hearing is filed, the CAPA guides the proceedings and the hearing. If there is an immediate danger to public health, safety, or welfare, the CRC may suspend a license without giving the licensee notice and an opportunity for a hearing, but the licensee does have the ability to appeal an emergency order in district court. And then the last item I'm going to cover in terms of the training is the Kansas Tort Claims Act. Under the Kansas Tort Claims Act, it generally governs the liability of state of Kansas employees and agencies, and an employee, including a member of the board or committee of a governmental entity, including elected or appointed officials and persons acting on behalf of the service or in service of a governmental entity or official capacity, whether or with or without compensation. So the Kansas Tort Claims Act, as we have understood, covers board members and also advisory committee members for the board. And the basic rule of the Kansas Tort Claims Act is that vicarious liability for any actionable wrongful act or omission, governmental employees within the course of the scope of their employment, subject to affirmative grants of immunity that may exist on a case-by-case basis. So if you are sued for an act that occurred within the scope of your duties as a board member or an advisory committee member, you are entitled to have the state defend you at no cost. And then to obtain representation by the state, you must submit a written request within 15 days after you receive a service of process, including a copy of the petition and summons, and cooperate in your defense. And the state may choose not to defend you if you acted with actual fraud or malice, or if you failed to make a timely request for representation. The general rule is the state will pay for any judgment rendered against you unless the judgment is for an act or omission that occurred outside the scope of your duties as a board member or advisory committee member, or you failed to cooperate with your defense, or you acted with actual fraud or malice. So that concludes the training. I know I covered quite a bit of material in that. I think a lot of it is helpful to hear. I know some of you may have already heard a lot of that information during past annual trainings, but I think especially concerning why we do a lot of the things with the formality we do, I think it's helpful to kind of have a better understanding of the CORA, the COMA, the CAPA, And so I wanted to provide that information to you and also kind of walk through some of those items in terms of the documents on the board's website, a little history of the BSRB. So hopefully that information is helpful. But I'll go ahead and end that training now and see if any of you had questions that came up while the training was going on, or if you have questions about any other items related to training for the BSRB.
David, would those slides be available if we needed to go back and look at them?
Yes, and I'll go ahead and I'll send out, I will try to send out a PDF of those slides to members of the advisory committee. If it is too large, I might have to break it into a couple different pieces. But I will make sure those slides are available, and we'll go ahead and post a copy of those on the website as well.
Okay, any other questions? Okay, thank you, David. That is a lot of information. I think the other things on our list include just reminders of upcoming meetings. I think we're already on the schedule for our April 11th meeting. At least it's on my calendar. So maybe that's already been pushed out to everyone else. And then there's a June meeting, June 13th. So those, just make sure those are on your calendar. And if there's conflicts, let us know. And beyond that, I think we are ready for a motion to adjourn.
I can move that we adjourn.
Second.
All right. Well, then all in favor?
Aye.
Okay.
Aye.
Okay. Well, thank you all very much and have a good evening.
Thanks, everyone.
Bye.
Bye-bye.
Good night.